We have an apology from Mr. Fitzjackson, also from Portmore. The big churches are in Portmore, you know. Senator, how do they put you at the back today, you know, the one lady? Senator Motley, how do they have you put you in that seat today? How do they put you at the back seat today? No, I chose. You chose? Can't tell you. You see, but when she sits before me, you know, Senator, you're much easier on the eye than these men, you know. I can look at a laugh meeting. Mr. Chuck would apologize, but he's withdrawing his apology. It's here. I'm going to take the minutes having been read. Well, before I get to the confirmation, this week we're going to have a fair amount of presentation. It will appear that there's more increasing interest now that the matter has started in Parliament. So we'll take the presentation this week. But I'm going to take the minutes having been read and ask for confirmation from minutes for January 13 and 20. Minister Chuck, since you come with apology. No, you're at both meetings? No, yes, but I haven't read the message. I thought... Any corrections? Mr. Bepp. And seconded by Minister Chuck. No, Member Paulwell. Mr. Chuck, you know you're the reader in the government, you know. I just want them, I didn't see them before. You're assisted by Minister Williams and the AG, but you're the official reader. I just said I won't take any matters arising from the minutes if there are no corrections. I think we'll try and do the presentation this week. Is that all right? Yeah. So we're going to begin with Minister Chuck's Minister Restorative Justice Program. A nice program come from the Minister of Justice. Listen. Sure. No, when you look at the prison, I'm not into that one. You like to look. It's your cultural habit of send them to Maypen and give. So we have a delegation led by the Chief Technical Director, but Ms. Lindsay will do the presentation. And the officers from Tivoli, Denham Town, and Trench Town. Why you bring those officers? You can't restore the body in Kingston. They're not subject. We have people who are... You send the poor people to frustrate them? These are beyond irredeemable characters you're dealing with down here, so. Send them to Montego Bay and Maypen. So we invite Ms. Lindsay. Thank you.
Good afternoon, Minister Chang, Minister Chuck, ministers, other ministers, ladies and gentlemen of the House. My name is Andreen Lindsay. I'm the Restorative Justice Program Coordinator at the Ministry of Justice. And today, it's my pleasure to be here with you to present on the topic of restorative justice and the zones of special operations. So the definition, just looking at the definition of restorative justice in a nutshell is really a process whereby the victim, the offender, and members of the community are brought together in a process to talk about what has happened and how we can move forward to a successful future. So you see here the working definition, a process whereby all the parties with a stake in a particular offence come together to resolve how to deal with the aftermath of the offence and its implications for the future. And as we go through the presentation, you will see more of what this process entails. Essentially, though, restorative justice is a process that does promote peace through reconciliation, which is key, and it places an emphasis on repairing the harm done to people, relationships, and the community. So why restorative justice? Why has the ministry chosen this program? There was a research conducted by Will Stevenson in 2012, and what it showed is that a review of 36 countries, RJ increased the satisfaction of those affected by conflict. It's very effective. Rather than using the system traditionally that we used, using RJ as an alternative method of dealing with crime and violence, there was reduced feelings of revenge, and we know that in Jamaica, the reprisal culture is a big deal, and we find that a lot of crime and violence that is committed is through the sense of reprisal, through the need for reprisal. So RJ addresses these needs, and it was found, as I said, that in a review of 36 countries, it showed these effective measures for RJ. This here is just demonstrating the main differences between RJ and the criminal justice system. You'll see here the criminal justice systems ask three main questions. What law was broken, who broke it, and how do we punish them? However, in restorative justice, we're more looking at what harm was done and who was the harm done to, what needs have arisen based on that harm, and what obligations do these needs to be met. So what is the RJ vision and mission? It's there. Essentially, improved and efficient justice system, which is what we all want for us here in Jamaica. Through the delivery of high-quality restorative justice practices across Jamaica, rebuilding relationships and community by fostering empathy, healing, and responsibility for all citizens. Accountability, one thing about restorative justice as well, we will see as we progress, that accountability, taking responsibility for one's actions, is very important. The mission is to institutionalize an evidence-based program to reduce the demands on the justice system. As we know, in the courts presently, there is an excessive backlog of cases, and RJ was designed to really address that need. It's used in schools, in families, communities, and also in workplaces as well. So how did we come to restorative justice in Jamaica? It was really developed after the 2003 West Kingston Commission of Inquiries report. That was a recommendation that came out of there. The MOJ has portfolio responsibility, and the policy was approved in 2012 in Cabinet. The first centre was opened in Tower Hill on February 6, 2012. That's on Olympic Way. And the Law Reform Miscellaneous Amendments Restorative Justice Act 2016 was passed and came into effect in the same year. So how has the ministry progressed since 2012? Here is a map, and you will see that the Ministry of Justice, previously with support from CSJP, has established 11 parish justice centres and 7 restorative justice centres all across the island. These red dots indicate where our centres are. So in total, we're operating out of 18 centres. So we are in every single parish in Jamaica, and in Kingston, there are 6 centres. So you can see we are definitely set up to serve the citizens of this country. I should say, actually, on the slide before, that in each of our centres, we have a restorative justice officer. Also, we have a community liaison officer, and that person's responsibility really is to be the liaison, that key person between the community and the centre and the Ministry of Justice, to build those key stakeholder relationships and to tell us what's happening on the ground so we can act accordingly. The framework for restorative justice in Jamaica. So I mentioned before the Law Reform Miscellaneous Amendments Act. And this act really strives to amend several pieces of legislation, which you will see here. The Criminal Justice Act, the Child Care and Protection Act, Corrections Act, and the Parole Rules. So at this time, we don't have a single Restorative Justice Act which stands by itself. What this act served to do was to really amend the acts that is laid out on this slide. So what are the points of entry into the restorative justice program? How do we take in referrals? Importantly to say, referrals can be taken in or received from anybody in the community. It could be a resident of the community, a teacher, a police officer, a JP, a teacher, and this is at the dispute stage, so the pre-charge stage. And we have found that this stage is really critical because early intervention for restorative justice, this is a key theme, early intervention. What we have found is at this stage, if referrals are made at this stage and we intervene before a charge can even be brought, then we can really look to speak to people, bring them together, and see how best they can work out the situation before it escalates into a bigger situation, which is what we want to avoid. Because oftentimes, the smallest of things can lead to murder and a lot of violence. So we really want to try to get more referrals in at this point so we can reduce those escalations in situations. We also have next the post-charge, pre-trial. Again, we have a considerably amount, and I think at this point, the next couple of slides will demonstrate it, but at this point, we receive most of our referrals at the pre-trial, post-charge stage, which is made by the courts. The parish courts is where we receive the most of our referrals. We also have stage 3, which is the post-conviction, pre-sentencing stage. This is very underused, and from looking at the research, the data, and my own knowledge, we have not yet had any referrals from the courts for pre-sentencing. The final one is post-sentencing, and this is once the offender, the case has gone through the requisite system, the requisite procedures in the court. What we would want, what the point of entry is that the judge would make a determination that you've been sentenced, but also restorative justice is a tool that can be utilized in your case to address what has taken place. We really want to see more of those. And at the moment, I should say, it will go on in a further slide, but just to introduce the idea to you now, post-sentencing is something that we're really working on with the Department of Corrections. And you will see, we will demonstrate later how we have worked with them and addressed the needs of inmates in correctional centres once they have been sentenced and are serving their sentence. And I say the needs of offenders, but also the needs of victims, because we're bringing those two together along with the community. Very critical. Okay, so this is just to give you really an idea of the process flow. Once a referral is received, what happens? Details of the parties are taken, we are given an overview of the offence and details of the referral source. So we get the referrals into the centre with the requisite information, and what we then do is arrange what we call a pre-meeting, which is a pre-conference session. In that meeting, we're really constantly doing a risk assessment to ascertain the situation for the victim, for the offender, and for the community representative. Because one thing we know in restorative justice is that timing is critical. So if we try to have an intervention before parties are ready, that can cause a breakdown. So we try to make sure that we're constantly assessing the situation at this stage to see their readiness to move on to the conference where they sit down together. In the pre-conference session, we also explain to them the RJ process, what will happen, and really lay out the expectations so that when they come to the conference, then they know what to expect. Because the one thing we don't want is for people to come very anxious into the they're already anxious, actually, when they come to the conference, but we want them to be relaxed. So we try to give them a full overview of what is going to happen, what are the principles of RJ, what are the expectations, what are the processes, what does the agreement entail. We really give them a full understanding of what will happen and what everyone's roles are. And importantly to add at this stage, what we also want to understand is their expectations, because it's very important for us to know what they would expect. When an offender comes to a pre-meeting, an individual pre-meeting, or when a victim comes, if the victim, for example, says, okay, I'm thinking, okay, I was assaulted, and I think that, what I want is $1 million. When we speak with the offender, we can ascertain, is this a reality or not? Because what we don't want to do is to set up the victim for any disappointments. So we really want to set the expectation and set the tone and understand their expectation in this meeting. Generally, when we have done some research, research has shown that the pre-conference stage is where we spend the most time. So we don't rush through the process and try to get the information. For us, it's not just about getting to the conference. It's really about understanding the needs of our clients. So we take the most time in this part of the process. The third stage of the process is the RJ session itself, the Restorative Justice Conference itself. And this really includes facilitator, a co-facilitator, the victim, the offender, and the representative from the community. And it's in three main stages: the story sharing, an open discussion, and the agreement. With the story sharing, this is an opportunity for the victim and the offender to tell their story. What happened? We have certain questions. What happened? How were you feeling at the time? What has happened since? And what would you like to see happen? And again, these questions are asked of both parties to really understand their side of the story. And for the victim and for the offender, the most of the feedback that we get is that this is the first time they've heard that person speak. So in family conflicts particularly, it's quite moving to be in a session, because when they say, you know, they talk about what led up to the dispute, because oftentimes, you know, the other party doesn't understand the underlying issues that has brought them to this stage. And when they understand it, they come in and you can see that people are really angry and they're sitting with their backs turned to each other. They don't want to talk to the other person. And by the time they tell their stories and we start to unpick what happened, you see people really starting to relax and to understand each other. And don't get me wrong, I'm not saying this happens in every conference, because, you know, we understand that people are people. And it's not every time that we have a conference there's going to be a successful agreement, because some people, even though in the pre-meeting they appeared to be ready for the session, when we actually get to the conference, you see that they are still very hurt by what took place, and they're not really at that place of readiness, and we understand that. But most times we do, and we have around 92% successful agreement rate, so it is a very successful program, and we'll speak to the numbers as we proceed in the presentation. But it's really moving, and I don't think I can explain enough to see the people changing. It's a transformational program, because as I said, they come in and they're so angry and everything is just so rigid, and to see them kind of just take it down, it really is an experience. And we encourage people, you know, our community leaders, to really come to conferences to observe the process, because us telling you the process is very good, is very important, but you seeing the process and understanding the process yourself is even better. And then the final stage of the RJ process flow is the follow-up. So after they have come to the agreement, if they come to an agreement, and they sign the documents, and they agree to the terms, I'll pay him this, or I'll do this, we will live good. What we do at Restorative Justice, we also follow up. We don't just say, okay, thank you for coming, see you, go home. No, we monitor, check on the compliance of the agreement for at least kind of 3 to 6 months, on a case-by-case basis, to see how the agreement has progressed. Have they lived up to expectations? Has the agreement broken down? If the agreement has broken down, can we reconvene to see what we can do to get the agreement back on track? So we look at that during the terms of the compliance stage. Very important. And the feedback, we constantly get feedback from parties, and the feedback that we always get is that they really enjoy that part of the process, because it keeps them focused as well. So I mentioned earlier about sources of referrals into the program, and you will see here a chart that we have designed, and this will take you really from 2017 to present, well, to the end of last year. You will see how the program has really developed and grown across the years. Just for an example here, from the court in 2017, we had just 99 referrals into the program from the courts across the island in 2017. In 2018, that jumped to 745 referrals. And last year, that was 1,450. In 2019, 1,501. So you can see the excessive climb in the numbers. So the court, and I think when we've had sessions with the judges and received feedback, most of what they say is that they have grown in confidence because they have seen the impact that the program can make. They've seen that the impact the program is making, and they themselves receive feedback from our clients saying about how impactful and how satisfying the process have been, and that encourages them to send more referrals to the restorative justice program. And you will see also with the police, in 2017, we had just 31 referrals, and by 2020, last year, we had 228. Now, for me, this is an area that I'm very passionate about because I would have mentioned earlier that early intervention is key. And for community policing, we're aware that police on the ground, they are aware of conflicts and disputes going on. But I think from what I've observed myself is that the referrals sometimes are made too late. They're not intervening early enough. And that's why I think, and again, we will go on to discuss this further as we look at restorative justice in the ZOSO, but the police are a key stakeholder in recognizing what's happening in the communities and bringing those matters to RJ. We really need to work much more close with the police to make sure that we're intervening early enough to make that difference that we want to see in these situations. And just to give you some practice examples, this is just an overview of some of the referrals that we have received into the program. And we'll give you some specific referral examples as well. But from schools, which is at the community entry points, we have received simple things from name calling to more serious issues like bullying. From the police, we've received kind of domestics and family disputes. Parish court, pre-trial stage, assaults. We've even received circuit court matters at the pre-sentence stage, wounding with intent. And then for DCS, post-conviction, post-sentence, murder. So from one end of the spectrum, you can see here just a quick glimpse. From name calling, restorative justice has been designed in a way that it can deal with the minor issues, but it can also speak to major issues. So from smaller incidences like name calling, going to assault, and all the way to the end of the spectrum to murder, you can see the wide range of referrals that we receive. And this is just really designed to give you a quick glimpse. But we have much more cases than this. Just last week, myself and my administrator in the unit was collating all of the information about the different crimes or different disputes that come into restorative justice. And we had about 8 sheets of paper because there were so many different things: MDOP, assault, wounding with intent, family dispute, name calling, bullying, threats, theft, burglary. There's so many. But just to give you a kind of, like I said, a glimpse and a synopsis of the kind of things we deal with. And we will speak to some specific examples just to further give you an understanding. So looking at RJ and the ZOSO specifically now, getting to the meat of the matter, I wanted to start with this quote from a gang member. He says, "A gang is the gateway to freedom. Freedom from parents, rules, and guidance. Freedom to be whatever you want to be on the negative side of life. Being a member of a gang gives power, security from those who would normally beat you up and take advantage of you. When you are a member and have a gun, that is everything." That's profound, and I just want to take a minute for everyone to just really get that. That's actually from a gang member. That's a direct quotation. Here in Jamaica, in one of the downtown communities. So you can see from this, and we know that gangs are formed as they're recruited from as young as 7, even younger than that sometimes. So if this is the view, and this is the view of a gang member, we can see, again, I mentioned earlier about early intervention, and this goes to demonstrate that actually early intervention is key in the schools, in the communities, because if this is the view, if this is how they view being in a gang, a gateway to freedom, that is powerful. And, you know, having a gun is everything, and we have to look at the kind of role models that we have as well, because some young people, a lot of young people, they aspire to that, and we need to create something better. And these social intervention programs that have been designed really are a path to something that is more transformational and positive into the community. So we really need to look at how we can scale up these kind of programs and roll them out across our communities to have a more positive and lasting impact. Okay, so I've added about the ZOSO Act, and I'll briefly go through it. I'm sure all the members are aware of what the ZOSO Act does say. I'll skip that, these 3 slides, which is just an overview of the Act. Okay, so looking at ZOSO and RJ specifically, one of the things I highlighted, I saw in the Act, one of the aims of ZOSO is towards a sustainable development plan for ZOSO communities effectively. And these are the things that we think how ZOSO can benefit from RJ. That's contributing to the reduction of antisocial behavior, building trust between police, authorities, and communities. And again, I'll just pause there to say that one of the things, when we speak to people about the police and community policing, one of the most common things they say is that they don't trust the police. And we need to look at how we can build that trust. And restorative justice creates a pathway, how we can use the processes and principles of this social intervention program to build trust and create more improved communities. So you'll see here further, to empower community members, to support building stronger communities, reduce recidivism and prevent recurrences of crime, and to promote inclusivity and give communities an opportunity to dialogue in a safe space. This is another, I just want to again lament on that, this is another bit of feedback that we get that I always listen to and I think is very important. That opportunity to dialogue in a safe space, people really appreciate that because, again, if they feel they can't trust the police, in most instances, and can't go to the police, then we have a problem, because that means that when things are happening, the police are not being told, they don't know about it. If we can create an atmosphere of trust and where they feel they can dialogue in a safer space, then we're working towards a better community space. So as it relates to RJ in current ZOSO locations, you can see here, so for the 4 ZOSO locations we currently have, in Kingston, we have Greenwich Farm, and we have the Trench Town RJ Centre in that location, or that will serve that location. August Town I have on this, which was sent a few weeks ago, it was currently closed. I'm sure the members would be aware that on the 2nd of February, last week, Tuesday, we reopened August Town RJ Centre, so that's now operational. Denham Town Restorative Justice Centre, and actually Denham Town, represented here today by Miss Campbell, is actually right next to the ZOSO post and work very closely with the ZOSO personnel there on the ground. And for Mount Salem, we also have the St. James RJ Centre. Now, the numbers are not on this slide, but just to give you an idea of the kind of cases or the number of cases that we're dealing with, for last year, Trench Town had 70 cases and 37 community sensitizations. In August Town, we was working through St. Andrew Justice Centre. There was 156 conferences. In Denham Town, we had 87 conferences and 37 sensitizations. And also, Tivoli, we are represented here today as well, Tivoli. Tivoli is not currently in a ZOSO, but we are aware that it can be a very volatile community. And last year, Tivoli had conducted 156 conferences. So again, you see from those numbers, the Restorative Justice Program is truly making impact and really addressing some of the needs that are in the community. You'll see here the representation displayed on a bar chart of what I just spoke about there. Denham Town, Tivoli, Trench Town, and Montego Bay. There for you to see in a bar chart representation. So, RJ challenges in ZOSO communities. So the feedback we've got from ZOSO community is that security considerations for RJ staff. Because some staff have reported that in some communities, there are times where they feel unsafe. They've heard gunshots firing. You're thinking, is it safe to leave the centre? Is it safe to return to the centre? So there is some feelings of insecurity within the community sometimes. So we're very mindful of that. As it relates to ZOSO and RJ opportunities, though, in communities of ZOSO, as I mentioned earlier, crime prevention should be viewed as a long-term goal. Crime reduction should be viewed as an immediate need. And RJ can be applied as a long-term preventative process, but can also address the need for immediate crime reduction. Because as we know, when it comes to crime prevention is not an overnight thing, and we see that happening right now in the country. It's more of a long-term goal, how we can work towards reducing crime or preventing crime over a period of time. However, when it comes to reducing crime, this can be viewed as an immediate need. And what we can do with RJ, we can use RJ to address the immediate needs of the community with a view to reducing those numbers. So how? So the opportunities flowing from the Act here, you will see. On the left, we have the sections, some sections there, 2 sections of the ZOSO Act. And on the right, this is where we have identified the opportunities that can come from restorative justice. Remedial work is necessary to mitigate feelings of retribution, either against the state or other individuals. And as I had alluded to earlier, what we have found is that a lot of violence, crime and violence in the country does come from the feelings of retribution. So something happens, you don't feel that the traditional justice system has really served the situation as how you would like it to be served. So you think, jungle justice, I'm going to take actions into my own hands. But what we have found is if we address the feelings of how people are feeling and they have the opportunity to sit down with those stakeholders, with the victim, with the offenders, with the members of the community and talk about it, then that can mitigate. And again, I just rush to say that this will not work in all situations. There is no method, I think, that can work for every situation. Each is on a case-by-case basis. But we have seen and we know that when RJ is applied to certain situations, this can assist the situation and mitigate against an escalation of crime and violence. And again, when we look at arrest and detention in the Act, what we feel would be beneficial is that when individuals were released into the community from being arrested, instead of just saying release and go, what we can do there is an RJ intervention. Because when people are just released and go, they feel angry. They think, okay, I was arrested, nothing has happened. And again, they feel that they want to do something to escalate. And that could be, again, we've had instances in the ZOSO where the community and the ZOSO personnel have caught up because of those feelings of anger, of hurt. And again, the opportunity to sit down and discuss these issues and these matters will not in all cases, but in a lot of cases, mitigate against an escalation in the situation. So looking at key strategies and opportunities. Again, from what we have just discussed going on from there, an increase in RJ case conferences. And what will this do? This will require an increase in referrals through strengthened partnerships with the security forces and other stakeholders. And I must say the staff who work in the downtown areas, they work very closely with the personnel. When I call downtown or when I visit downtown, I can always pop into the police station and they know the staff's names down there. So I know they have a very close partnership. I too myself speak with Sanko all the time, so I know I try to keep abreast of what's happening as well in the communities, and try to influence the police and other stakeholders to increase the referrals to the justice centres, to the restorative justice centres, so that we can address some of these feelings of dissatisfaction. An increase in RJ parent sessions to really educate parents about alternative parenting methods. In the traditional justice system, this is something that is often missing. When a victim and offender goes to court, a sentence is passed, and oftentimes it's just the victim and the immediate offender. But with restorative justice, it's about looking at the bigger picture and how can we also speak to the parents, the families, the community members, and alleviate their anger as well. And then an increase in RJ youth sessions. And I've put here 5 years old. I spoke earlier about early intervention and losing our young people to gang warfares. But really what we need is a re-socialization strategy. And if we can educate young people from an earlier age and engage them in positivity and sustain it. And I say that because I don't think it's enough to just say we're doing a few sessions today and maybe do some next year. We have to have a sustainable approach. Consistency is very important, because for young people to learn and relearn a new strategy, this is something that takes time. It's not going to be something that's an overnight process. So we really need patience and understanding and a strategy that can be consistent and ongoing. And then finally, just to say that training is another thing. Increased training in restorative justice practices. So last year, myself and another of the RJ officers conducted training to 44 personnel from the ZOSO communities. And this was something that we had planned to roll out across last year. We started in March, and I think it literally, as soon as we had finished that one and was to move to the others, then COVID-19 came and we had to suspend our efforts, which is a shame, because the feedback we got from those 44 officers, they said that they felt that a program like restorative justice should really be given to all of the ZOSO personnel, so that everyone has an understanding and has this as an additional tool, not the answer, but an additional tool in their toolkit of how to deal with conflicts in the ZOSO areas. I mentioned before strengthening partnerships, and that's with JCF and JDF to work closely with RJ centres in the respective communities. And again, I can't mention enough about early intervention, because I truly do think that early intervention is the key. Just as a side, in the UK, I was a child protection social worker, and one of the things we practiced, as soon as a school, for example, made us aware about a family in conflict or a family experiencing difficulties, straight away we would go and visit that family and design a package of support for them. And what we found is that the earlier we were able to intervene with those families, it was less likely that we would remove the children from them. So again, I tried to follow this principle in RJ as well, applying things very early and having those interventions set up to address the needs of the communities. And finally, for RJ to attend meetings, this for me is, again, a very important aspect of working together. The RJ representatives, the officers that are in these communities, it's our view for them to be invited to weekly meetings. And that's a two-way thing, for us to give information to the stakeholders, and also for the stakeholders to give us information. So if they referred a case, for example, we can give them an update. How has the case gone? What's happened? Where is it at? What's the stage? And again, if they have new cases, to refer those to us for our intervention. So I would say, all in all, RJ really applying restorative justice in the ZOSO communities, which we have done so far, but on a minimal scale. We have done this, and we have not done it in any strategic way. What we need to do is really scale up our operations and look to see how we can apply restorative justice strategically in the zones of operations. And really, the Ministry of Justice and our Honourable Minister is very committed to carrying out, especially the training sessions, because we believe training is one of the key things that we need to do. And money, I could hear our minister there saying funding. And funding is obviously critical, and I hope that the members of the House today can see the benefit of this program and look to see how we can add additional funding to the program to carry out some of these strengthening of partnerships and increasing the trainings across the zones of special operations. So thank you very much. At this time, if the speaker would permit, I would like I have with me today here Miss Lena Campbell, RJ Officer, and Miss Sasha Ebanks, and I've asked them to really give some examples. I wanted the House to understand the kind of conflicts that we deal with, so they have prepared some live examples of the conflicts they've dealt with, and if the speaker would permit, I'd like them to just have a few minutes to be able to relay those instances. Thank you.
Good afternoon, Minister Chuck, Minister Chang, and the other members of the House. My name is Lena Campbell, and I am a center manager in the Denham Town area. I will focus a little on the value and the importance of the restorative justice in volatile communities, and especially in the zones of special operations. As we know, crime and violence seem to be the order of the day, I would say, in Denham Town community, where I am daily. There are days when I wonder if I would be able to go into Denham Town to conduct my daily work. And at other times, I'm thinking, will I be able to get out of Denham Town after hearing some gunshots? You know, those are real experiences for us in those volatile communities. The only thing sometimes that really gives me hope is the people who really need our help there, and also when we see the soldiers and the police who are there to offer their service of protection. Ladies and gentlemen, we are aware that there is a different kind of culture in these zones of special operation that we should not forget. That many Jamaicans are not aware of that. The culture that have been fed and nourished over the many years cannot be easily eradicated unless serious alternative education and re-socialization measures are done in these communities. The value of building relationships, extending kindness, love, and peace seems to be the least in our crime-fighting strategy or methods, which are the principles that the restorative justice process is founded on. The restorative justice and the police, where I am at, need to be working more closely for a positive impact on the communities in the zones of special operations and by extension across Jamaica. I will share with you two examples of two cases that I've dealt with involving the security forces. One was with a soldier and a teenager who was resisting arrest, and while doing so injured the soldier by bursting his mouth. The matter was referred to us by the court. Both parties brought their supporters, 2 supporters each. In that session, one of the teenager supporter was a student lawyer who came from that community, and she was a family member. The behavior and attitude that was demonstrated by the family members and the offender was undesirable. The important thing that came out of the conference was that even though their behavior was negative, the victim, who was the soldier, was able to respond in a positive way, and the matter reached a resolution. In that space, the community, support persons, and the victim were able to counsel with the teenager offender, where he was able to accept accountability for his actions. And positive counsel was given to him by the community supporters and the soldier himself, who was a victim. And to hear the soldier being able to counsel this young teenager who was going down the wrong path. You know, it was very interesting. We had another scenario with 2 police officers. They came upon a teenager who was throwing bottles and stones in the night at some other girls on the street. Now, they said that there was no light in the community at that time, so the whole community was dark. The officers could not control the situation by speaking to the teenager who was throwing the bottles and stones. They told her to desist from what she was doing, but she refused to stop doing what she was doing. She continued, even though there were 2 officers present. The officers had to resort to firing their firearm in the air to control the crowd and to apprehend the individual who was throwing the bottles and stones. In carrying out that act, one of the police officers was hit by the teenager with a stone she had in her hand to his face and his head that caused him and the teenager to fall to the ground. While on the ground, 2 other teenagers who were family members attacked the officer, where he was then receiving other blows to his body. In that incident, both officers were assaulted. Here again in this space, in the Restorative Justice Conference, both sides were able to express their feelings and persons were better understood by each other. The question was asked by one of the facilitators to the 3 teenagers that were charged, how the police could have handled the situation better. Was there a better way they could have dealt with the situation? The 3 teenagers sat there thinking. Then one said to the facilitator, "No, miss, it could not have been handled better." This question was asked because the parents who were there was upset about how the officers had dealt with the situation. Reaching this point, they were now open to counsel, and the officers could give guidance with the parents who were also present. The restorative justice space may seem simple, but it is a dynamic space to see and understand things differently. We have a culture to fix in these communities. The restorative justice process teaches that we should not do things for the people, but to do things with them. The Minister of Justice always refers to Jesus' method of forgiveness and repentance whenever he speaks on the topic of restorative justice. I will also mention that Jesus did things for the people, and he also did things for them, with them. He went into their space and taught them, transforming their lives. That is what restorative justice is about. The Restorative Justice Center in Denham Town have realized that we are there to do things with the members of the community. If we want transformation in these communities, we must institute a preventative method in reducing crime and violence in the zones of special operations. The very persons who may have caused crime and violence to grow and multiply in these communities are the persons who are to be targeted to help solve the problem. And these persons are parents. Teenagers and young adults do many crime and violence. Parents are responsible for many of the atrocities that have happened in these communities because they lack positive parental skills. In Denham Town, we have initiated a restorative justice 2-day parental workshop that had commenced in June 2020. We were able to reach 80 parents. A club was formed out of the parents who were trained in these 2-day workshops. We have heard many and dangerous stories in these workshops of the escapades that parents have participated in with their children who are going against the law. I will share some feedback with you as to what these sessions have done for these parents. The president of the club states, when he was asked what impact the sessions had on him, he said, The sessions were very informative. I learned how to be a better father, husband, and a better man. I learned how to relate not just to my children, but to other children, how to control my anger, and to be patient with children. He also states, I was not giving my son the attention he needed because of his behavior. I thought he was bad. He wanted to take up scamming. He also had a ring that he wears. His aunt told me it was a guard ring because of the company he was involved with. After attending the restorative justice parenting sessions, I reached out to my son and practiced what I had learned. He continued. My son told me that no one was giving him any attention, so he was doing the negative things to get his father's attention. At that time, he said, I was not showing him any love as a father. After talking to him, encouraging him, he gave the ring to his grandmother, and she threw it away. His grades in school was at 54% and had climbed to 87% after he gave him the attention that he needed. He is now 18 years old and working in construction. The father said, now we have a strong relationship. Anywhere he's going, he calls me to let me know. This program has helped me to build a bond with my 3 children. The Restorative Parenting Club have taught me how to be a good leader and to be thankful for what I have. I feel excited about what I have learned. The secretary of the Restorative Parenting Club also states, my life has been changed. I see things differently. I have grown spiritually, and it builds my self-esteem and give me confidence. I make greater effort to give attention to my son's needs. I now make sure that he is protected and is not involved with the wrong persons. This is the first program that I have participated in the community. I am now empowered and motivated. Since the Restorative Parenting Club has been formed, the members have accomplished the following. They have had prayer breakfasts for the community, praying for the community, for the borders that they say separates them from entering into one section, one road. They cannot go. They are praying that this situation will be fixed. They have also conducted healing circles on Sundays where parents can come and speak of their parental problems and share and encourage each other. They have delivered 63 care packages to the elderly in the community using their own resources and asking others for help to assist. Their slogan in this venture was, RJ have taught us how to be kind. Our general objective of this workshop is to provide support for parents, guardians, and other caregivers via information on the current positive child rearing practices within the Denham Town community, to discuss with parents the rights of a child and the national vision for parenting, that every parent in Jamaica, by birth, adoption, or guardianship, recognizes and accepts their duty to ensure that the rights of a child are always promoted, that the child is always loved and provided with opportunities and resources within a safe, caring, and nurturing environment to achieve his or her full potential and ultimate fulfillment. And this is a quote from the National Parenting Policy 2009. Utilizing the restorative practices and circles in the home environment effectively and incorporating the use of circles in each topic that is presented in the parenting workshops. Ladies and gentlemen, this program that I've presented to you, we need funding at this time to continue. We have had to pause because we could not continue to provide the refreshment that is needed. Also in regards to the contribution of care packages for the elderly that the parents have come together to achieve, we would want this venture to be an ongoing one. I have all confidence that this restorative justice parenting program, if continued, will help reduce crime and violence in these communities. In closing, ladies and gentlemen, parents must take accountability for their children's actions by learning what is right to guide and nurture their children. If we tackle crime and violence in these volatile communities by targeting parents, we will be saving not only the children, but also the parents. It would not only stop there, but also our children and ourselves, while at the same time reducing crime and violence in our country, Jamaica. I thank you.
Go ahead, AG.
The presentation? Thank you, Chairman. Just quickly, didn't get your name. I was looking for the tag.
Lena Campbell.
Ms. Campbell and Ms. Lindsay, thank you for the very informative presentation. You began by saying that the culture in the community, a certain kind of culture, but you didn't really specify what it is. Got glimpses into it as you went into the presentation, but very often when measures are taken to deal with communities, particularly those that meet the criteria for a ZOSO intervention, concerns have been raised in the past as to whether they are being targeted. I remember, for example, when the Mount Salem ZOSO was declared, there was a hue and cry about a targeting and not necessarily that the government wanted to go in to deal with it. Just want to hear from you what it is that this culture looks like. That's the first thing. You also spoke about negative behavior when you had asked the question as to whether the situation could have been handled differently. But again, you didn't say what the behavior was that was labeled as negative. And then thirdly, you highlighted that parents are responsible for most of the atrocities. Want to hear a little bit more of that? And in mentioning the Restorative Justice Parenting Club, I want to know if you do any work in conjunction with the National Parenting Support Commission, or whether anything has been explored along that line. But very, very interested in hearing for the record what it is that you see and how do you define that culture. Because if you listen to commentaries, when the Parliament is passing laws, especially where security measures are concerned, the first point is whether there are going to be human rights abuses and exactly what is happening, and that, you know, there is stereotyping and targeting of the communities. And it begs the question as to whether collectively we are aware of the different features of different communities in the island. So I've loaded you up, but so important is the presentation, because you appreciated that an entire side of the ZOSO has to do with the social intervention, assessing the effectiveness and what differently can be done. But thank you.
The culture is what I will speak on first. It is as if children in that community, which I speak of, Denham Town, is as if they were born knowing what is crime and violence, how to be violent. Give you one scenario yesterday evening that just happened. I was coming out of the center to go home, and I saw two little boys. They're about 10, can't be older than 10 years old. And I saw one of them came up to the other and said, he had stones in his hand, 3 big stones. And he said, stab me now, stab me now. He was saying this to the other one, and the other one was just standing there, and, you know, his face was screwed up and all of that. And I was wondering what was happening, so I went up closer, and he kept on saying to the other one, and even when I was coming as an adult, he did not stop. He continued to push himself on the other one and said, stab me now, stab me now. And so I said, when I reached up to them, I said, stop it. Even that did not stop them. I said, stop what you are doing. Even that did not stop them. Now, another young man was coming behind me. And so when I passed them and I realized that they weren't responding to me at all. So the young man came and he said, no, break this up, because he was still in the other one face. Break this up. And he had to physically took one and take him around the other side. The other one still followed him around where the young man took him. And he said to him, he has a knife. Now I was saying to him, what little boy could have a knife? What is he talking about? And he said, sir, I have a knife. And he said he has it in here. And the young man reached inside, in his side, and when he took it out, I saw he took out a knife. It was a sharp knife, a pointed one. Now, I was so surprised for a 10-year-old to be walking with a knife. And, you know, he took the knife from him, and the other one said it's a lady knife down the road. So he took it and run off with it. And I was thinking in my mind, but look, 2 children could have died right here, or one could have died, and you know, the other one reaches somewhere else. 6-year-olds in this community, in their play, they talk violence. They act it out before you. There were 2 6-year-olds that normally would visit me at the center as I'm there on a daily basis. So I would let them come in and I would talk with them. And when they play in front of me, one would lie down on the floor and the other one would have set his hand like this and he's shooting him. And the other one on the floor would be just shaking up as if he's receiving the shot. Now, this is the culture that they know. They do not resolve their situation in talking. They resolve their situation in stabbing, in shooting, in stones, with bottles. And when the cases come in, women, mothers, these are who are on the street daily, throwing bottles, stabbing each other. Even these 2 little boys, one came and said to me, my aunt stabbed my mother the other day. You know, it is a very serious thing with violence in that community.
What does the extent of the family units that make up the community? So there are some basic building points, which I'm beginning to wonder if they're just academic and theoretical in certain contexts. Communities are made up of family units. What does that look like in the community?
Repeat the question, please.
The family unit. The family structure. Family structure.
Oh. Some homes are with fathers. You have many single-parent homes. You have homes where it is, many homes are in one section, and you will have single-parent mothers, but sometimes the fathers are not playing that fatherly role in the homes there. And if there are negatives there.
I don't want to take you off the track, and I know other members of the committee may have, but I just wanted to know what had caused you to conclude that parents are responsible for most of the atrocities, because that's a huge statement. It's a conclusion, which no doubt must be informed by something. Yes. And then you went to the parenting club and the relationship, if any, that has been built out with that and the National Parenting Support Commission.
I will go to the parenting sessions that we have conducted. And from these parents...
Chairman, Director, Minister, it's an excellent program. But I think there are 2 things I'd like before we continue the line of questioning, because it's an endless line of questioning we follow it to logically because it's very qualitative. I'd love to hear some more data, evidence in terms of what we need to do, because we'll look at legislation. So I need 2 things this committee needs. One, evidence of what is really happening. You know, what you gave us are very graphic and something unfortunately too common. But to lay down legislation, budget behind it, I need evidence, not a part of that. Data, in terms of numbers of families, children involved, incident involved, and what we need to do. And then, for this committee, I need to see how the legislation can contribute to that. The details and the qualitative details are important, but quite frankly, in another forum, which we need to be aware of. We are looking at the legislation that is supposed to provide a framework in which to correct these problems. So I need a bit more of that. We are getting the qualitative analysis is good for illustration, but not for the total discussion. I'd ask the members to try and keep their own questioning in those lines, and your response to look again at that. Okay? Thank you.
Just one question I would wish to ask. In fact, I will await the other presentations just to make a general comment. But in relation to your work, do you in any way relate to the peace management initiative, the PMIs, both in the corporate area and Montego Bay, in the work that you do, the peace management initiative?
We do work. We work with a number of stakeholders, so we don't work as a single entity by ourselves. We work with referrals from, for example, DRF, PMI, SDC. Yes, so we work with a number of stakeholders always, if we find that we might need some additional support from another entity, or so too them from us. If we need support from each other, then we all work in ways that we have a working together cohesive approach.
And also in response to whether or not we work with the Parenting Commission, yes, we do.
A quick follow-up to Member Paul's question. And I wasn't getting it clearly from your presentation, from the first presentation made. On the restorative justice and the program that you operate, if you are aware of a dispute within a community or between persons, are you saying that you are able to go in without them approaching you? So you become aware by whatever means, through your stakeholders or otherwise, you can step in, because under another program within communities where they have mediators, I was informed by a mediator that they are the persons in dispute would have to come to them. They do not go out, being aware of the dispute. Is there a difference in?
Okay, thank you for the question. If a situation is brought to our attention, a referral is received, what we do make contact with the persons that are involved. But the very important thing to say about the Restorative Justice Program is that it's a voluntary program. So when we contact the individuals, one thing we want is their buy-in, because forgiveness is not going to happen. Is if we're forcing you to come, then forgiveness might not take place. Because remember, I'd said earlier, one very key thing is about the place where they're at. The timing is very critical. So if it is that we approach them and say, we've received this referral, we've heard of the situation, we explain to them what restorative justice is. If they say, no, not interested at that time, we might decide not to proceed with it at that time because they are not at that ready state. But we will follow up again to see if we can make that intervention. If they're not ready, then we cannot intervene in the situation.
If I may add as well, in the Restorative Justice Program, we have community liaison officers who work within the community. So accessing or seeking to initiate the restorative process with the person, whether or not there is a referral, is easier for us. Thank you.
Chair, it will appear to me from your response, Ms. Campbell, that you are from outside the community and you go into the community. Given the culture that you spoke about, how does the community relate to you as an outsider?
Well, I would say the relationship, like any ordinary relationship, at the start of it. For example, in Tivoli Gardens Restorative Justice Center, where I'm located, when I started in 2017, there was some apprehension. But what I did, I met with the key stakeholders on the ground, the CDC president, justices of the peace within the community, teachers within the community, persons who are pastors and so on within the community, and we formed meaningful relationships with them. And so as time unfolded, persons willingly came to the RJ Center, and currently now we have such a wonderful relationship. Ms. Campbell spoke about wondering whether or not she should go to work on a particular day. Persons within the community will call me on my work phone to share with me what is happening in the community because of the relationship that we have formed. Restorative justice is not only about repairing harm, but building relationships. And we ourselves, as persons within the community, Tivoli Gardens, the RJ Center is right there. We're forming relationships with these citizens. And I want to also share that these citizens have particular needs. We speak about the culture of violence, but there's also a culture of hurt. Persons within Tivoli Gardens are deeply hurt, and they have long memories of what they see as atrocities that have been done to them as well. And so RJ is providing that opportunity for them to receive healing. And what is wonderful is that they're coming to us for these services to provide them with a healing. Mothers who are unable to control, quote unquote, control their children are coming to us for help. They're submitting themselves to us talking about restorative parenting trainings with them. So the relationship factor is very important, and the family and cohesiveness that we are feeling in the Tivoli Gardens Restorative Justice Center is as a result of us going into the community, going over PWD, going to over Rasta City, going around bumps, going in and around the community, walking out, not just waiting for them to come into the center, but for us to go to them. So there's a good relationship.
What's the breakdown of the RJ officers, gender-wise?
Repeat that, please.
Gender breakdown.
Oh, the gender of the RJ officers, off the top of my head, it's about, I'd say it's about 60-40 at the moment, male and female. We have a little bit more females. But we do, in each center, we do have a restorative justice officer and Ms. Ebanks, and we mentioned before, a community liaison officer. I'd say nearly in all our centers, we do have male and female, almost in all centers.
Let me join the sharing section for Minister Chuck.
And can I just add as well?
I want to join. I just want to ask. Where ZOSOs are declared, would it be your recommendation that the RJ Center accompany all the work in a ZOSO area?
No, so just to give a bit of context there, the Restorative Justice Program was first funded and operationalized by the Citizen Security and Justice Program as part of that initiative.
The question is that whether or not, since we are reviewing the ZOSO, whether when a ZOSO is declared, whether or not you think the country would benefit from an RJ Center being part of the things in the ZOSO.
Definitely the center or the services. As I've demonstrated, as we've demonstrated here today, and as Ms. Ebanks actually just said, the relationships are very important. And if the community can have a voice, restorative justice provides a voice and a safe space, and a space to build trust when we could bring people together. We can bring you together, a victim and offender together. But not only that, we can bring the police and the communities together, the stakeholders, and that is critical in going forward.
May I just in support of your point? Greenwich Farm has a ZOSO, and in fact, the leadership of Greenwich Farm came to us at the Ministry of Justice to bring the restorative justice there. So we went to the community center in Greenwich Farm. I must tell you, I went, and we have been training. We have trained 30 so far, facilitators, and they have begged us to return to train some more. So in fact, in Greenwich Farm, where the ZOSO is, they see it as a major positive.
Yeah.
So you're going to join us in making that recommendation as part of an amendment will be two other issues. Well, the presentation of Ms. Campbell, is it available to us so you could have a copy? I thought it was a good presentation. And there's another report we're going to look at later on from another agency that speaks to numerous detention of people in the communities under ZOSO. You find those detentions a source of conflict between the officers, the security forces, and the community? And how have you attempted to tackle those?
Thank you for the question. So we have not had any official referrals for those matters. However, when we conducted the training for the ZOSO, the 44 ZOSO personnel, some of the things that they shared was about the conflicts they have with community members. And they felt that if they had restorative justice, if they had the training, and if they could contact us and reach out to us to use the services, they felt that would be beneficial to them and to the community members as well.
Them, you're talking about the security forces?
Yes, that's correct.
Good. And have there been complaints to you from the community members about their interaction with the...
I'll give that to Ms. Campbell, Ms. Ebanks. Complaints. He was asking, he said complaints from there.
Yes, we have received complaints in regards to person being detained in ZOSO at their detention place. But there's one particular officer that is trained in restorative justice. And she would normally deal with those situations using the principles of restorative justice that she have learned to resolve many of those situations that has come into the detention area with those citizens.
Just a follow-up. I too want to congratulate the Restorative Justice Unit, and I must tell you I am deeply pleased to hear your presentation this afternoon, because I was in the vicinity of the building when it was just a concept. So it is quite an amazing thing to listen to how it has been implemented and how you're applying it to this particular situation in our country. So I have just two short questions, and following up a little bit on the question that Senator Brown asked. The restorative justice principles applied in a community, whether that's through a center or through just the services coming into the community. Is it your position, albeit you think it should be there in a ZOSO scenario, when is it not going to be there? So you go into a community that has been declared a zone of special operation. Is there a time at which you think the center or the services in the community will have expired their useful life there? Do you have a concept of there being some path of transformation at which point you will no longer be needed? Or is it your position that this is really a recommended institution in communities that are vulnerable communities like ZOSO communities, and perhaps extended to as many of our communities in Jamaica as we can extend it to?
Thank you. So first off, to say that, of course, we have 18 restorative justice centres across Jamaica. Firstly, to say it. Secondly, the point that you made is definitely an institutionalization of the program and the centers. Conflicts, we have to remember, even though we're here primarily speaking about ZOSOs, conflict is fluid. Conflict is an ongoing thing in life. And no matter what interventions we have, conflict will always exist. Therefore, there will always be a need and a requirement for services that are provided, like restorative justice and other social interventions. I think those services such as this is critical to community cohesiveness, and the continuity of the service will only add to building the communities and building trust in the communities. Of course, as well, one thing I wanted to add that kind of goes on your question, we're here primarily speaking about, of course, the ZOSOs, Kingston and Montego Bay, but I worked in Portland and I worked in St. Mary's, and again, restorative justice is also effective in those communities. When I first started here, I was in Portland, and the amount of cases that come from there, so even though the crime and violence is heightened in the ZOSOs, community conflicts are happening right across the country, and perhaps the restorative justice centers being in certain communities, that might be a preventative measure from things escalating and other areas becoming zones of special operations as well.
I thank you for that. Mr. Chairman, my question is partly led by the fact that I don't know about the other members of the committee, but as we've been sitting here and listening to the various presentations, one of the things that's screaming at me is this concept that there is no quick fix to this problem in our country, and to the extent that some of us as parliamentarians and some other community and political leaders have gotten up in different fora and blamed one government or the other for the problem that we're facing, we have to, if nothing else comes out of this committee, I hope that it comes out of this committee collectively that this is not a short-term problem, it's not a quick fix problem, and we have to look at long-term solutions to change our minds and change our culture in this country. And so my follow-up question to you, Ms. Lindsay, is what connection have you made, if any, with the Ministry of Education for the incorporation of restorative justice principles in the curriculum? I have 3 children under the age of 13, and they are not exposed to the kinds of things that the children in these communities are exposed to. But even in their very play, because of the video games or whatever it is that they're watching, it's about shooting, bang, bang, and catching this one and whatever, you know, explosions on the video games and so on, that I myself haven't even wrapped my mind around. But it's not even just a concern for communities that are as vulnerable as the ZOSO communities that have so been declared. So I want an understanding of, if you haven't done that, are you thinking about that? Is that an initiative that you think would be useful in relation to the work that you're doing, not just in ZOSO, but across Jamaica? Because as much as we're sitting here deliberating about ZOSO, Mr. Chairman, I think we have to understand that a lot of what is happening in the ZOSO communities are happening elsewhere, maybe at a smaller scale. Yes. Yeah, I appreciate your response to that one.
Yes, thank you. So we do have a memorandum of understanding with the Ministry of Education, and I don't have the exact figure today, but it's we've trained over 1,000 teachers in restorative practices, the 2-day trainings. We do that very regularly, and there is some set up to continue. We had a break due to the COVID. When it comes to children, though, as well, all of our centers across Jamaica go into schools and sensitize young children from very young age, from basic school age, coming up to graduation age. And it's funny you asked that, because only last week, literally, I had a guidance counselor requesting a schedule for us to do online sensitizations with that was only with grades 11 and 12. But what I had suggested, if we could just do it across the grades, because as we identified earlier, you know, conflict starts at a very young age, and just looking at grades 11 and 12, I'm not saying it's too late, but early intervention again is key. So if we can start that from 5 years old, 6 years old, right across. But I think there is something to be had about embedding restorative justice in the school curriculum as a module itself, just like English or math, because conflict resolution, you can be the best in English or maths, but not have those conflict resolution skills which RJ equips you with, and you're still in bigger problems.
Just to add, Chairman, if I may, the direction has been given to the RJ unit that we are going to train at least 3 teachers in every school across Jamaica. Now that started a year and a half ago, but the pandemic has really reduced it. But that is the instruction, and not only teachers, but the senior students will also be trained in restorative justice.
Minister Chuck, but you know, one of my concerns is when we approach it in that way and there's attrition in the school system, we lose the skill set. So I would love if, and I may push you on it outside of this forum, if we could have some discussions with the Minister of Education in relation to how could we look at this in the actual curriculum, so that it becomes a part of the guidance curriculum, or I think my son at Arden does home and family or something like that, but so that it actually becomes a part of the curriculum. I really feel so strongly about it, and I'm so heartened to hear the work that you're doing. Congratulations, and please continue. Despite those days that are demotivating, please continue to do the work that you're doing on behalf of our country. Thank you so much.
Thank you.
Thank you very much. A good note to end on. Let me commend the team, the ministry, and the work we're doing. That takes the end of this section. We're going to invite in the next presenter, but Dr. Henry, I'm going to ask to give us and allow Ms. Harris to go ahead of your team on the public defender. All right? Yeah. Those who have completed because of the current distancing rules, those who make their presentation, you have to ask them to leave. I know it would be nice to have hear what's being presented otherwise, but amen. You can stay. No, you're part of the team. It's the numbers that we're trying to sort out to keep at 11. Come. Colleagues, go now. Right. Thank you, colleagues. Let's settle again. Welcome our public defender and her team, Ms. Harrison Henry. And we have decided to take you on the second item, Ms. Henry, that Dr. Henry can have more time, but we figure we'd give you, let's say, ladies before gentlemen. Not though there's quite a few ladies with the POJ team, but we thought we'd take the public defender first. So we're going to ask you to introduce your team and make your presentation. As you're aware, this is you came, the committee looking at the Zones of Special Operations Act, and to examine not only its application, but what the objectives, if there needed to be any additional elements to the Act to make it more effective and credible in dealing with the community building that's designed to do, as well as what change we may need to make in the Act. That's the purpose of the committee at this stage of the game. So, Ms. Henry, welcome to the committee, and I said, introduce your team and then your presenter. Thank you.
Thank you, Chairman. Good afternoon, everyone. To my immediate right is Herbert McKenzie, Deputy Public Defender. To my left, Victor Hemmings, our Special Projects Manager. And to my left again, but in the second row, is Mrs. Kayla Beckford Harrison, our Director of Investigations, and I'm Arlene Harrison Henry. We thank you, Chairman and members of the committee, for giving us an opportunity to express our views. And our submissions, as you would see, Mr. Chairman, primarily deals with the actual operation of the zones, rather than, and we do make some commentary of what we have seen in the newspapers in relation to the intended amendment to the law. But we haven't seen any draft of any legislation, so our comments on that particular aspect of zones of special operations are very limited. So, Chairman, as time is on us, and as all of us know, the curfew starts earlier today, we would want to just move through as quickly as possible and highlight some areas of our submissions. So, for instance, Chairman, we know that we have had zones of operation in Mount Salem, Denham Town, Greenwich Town, August Town. And we know that the concept has been a concept around clearing, holding, and building. And it is a building phase that there is the assessment of conditions which exist within the zone, including physical infrastructure, health environment, land tenure, and housing. The Social Intervention Committee, established under Section 24 of the Act, is tasked with the responsibility of developing a sustainable development plan which will include addressing issues relating to health, the environment, social improvement, infrastructural development, education, and economic development. While the OPD was not able to ascertain the exact details or at all the extent of the work, worth, and success of Social Intervention Committee, it does appear to us, Chairman, that there are some financial challenges in relation to completing the building out of that last phase of the zone. Looking more closely at Mount Salem, which, as we all know, is a community in St. James Central. Mount Salem was the very first community in Jamaica to be declared a zone of special operation. The declaration came on the 1st of September 2017. Submission deals with the demarcation of the zone, and we move right along, Chairman, to the joint force activities in the zone. Based upon reports from the JCF, between the 1st day of September 2017 and the 15th day of August 2018, 582 persons were detained. Of that number, Chairman, 44% of persons detained were between the ages of 18 to 25 years old. 7% of those arrested and detained were children. 23% of persons detained during this period was between 26 to 30 years old. And of course, Chairman, as we have seen in other statistical data provided to us by the JCF, senior citizens are not spared from arrest and detention, as a cohort of persons between the age of 41 to 63 accounted for 11% of detainees. In summary, 74% of persons detained were 30 years and under. The most frequent occurring age among detainees was 23 years old, followed by ages 21 and 22. Now, in data provided to us, looking at paragraph 13, Chairman, on the cover letter of 2018-12-10, in respect of the 582 detainees, there was no reason stated for the detentions. Now, we all recall that Section 16 of the Act makes it mandatory that any person arrested or detained shall be forthwith taken before a justice of the peace. And our understanding of that law, and we engage in some of the training of justices of the peace, is that it is a justice who shall determine whether or not there are reasonable grounds for the arrest and detention. What we observed in the data provided by the JCF is that there is no reference or note of any arrested person or detainee having been taken before a justice of the peace as required by the Act. Paragraph 15, Chairman, data provided by the JCF in relation to this group of 582 detainees show that apart from one single detainee, none was charged, and each was released on the same day on which he was detained. Latter data, however, provided to OPD in the week of, probably about the 3rd week of January, contains reasons for the detention, but there's only, again, one detainee that was charged. It is of note that the latter data included 582 previously referred to. However, this latter data now carries reasons for the detention of each detainee. The outcome of the detained persons, however, remained the exact same, and that is all but one was actually charged and the others arrested, detained, and released on the same day that they were taken into custody.
I don't want to interrupt the public defender, but you're really saying one dege?
Yes,
582?
Yes, member.
No one dege.
Even though the reasons given for the detentions in the latter data are serious, Chairman, there is no indication in that data that anyone was taken before the justice of the peace or a parish court judge. Neither is there any indication that they were charged at all. Based on the data, they were arrested and released the very same day, but for one. This conduct by the police, as recorded in the data, causes one, Chairman, to question and this is a reasonable question as to whether there was any reasonable ground for the arrest and detentions in the first place. Paragraph 18 repeats what we have said. 582 taken into custody, 581 released without the intervention, Mr. Chairman, of the Justice of the Peace or the parish court judge. And the failure to take detainees before the Justice of the Peace, I think, would be concerning to all of us because of the separation of powers which is established in our Constitution. Chairman, if we look at page 4, we do a diagram that breaks out the ages of persons who are taken into custody. And of course, Chairman, just as a reminder to you and the committee, this is based on the data provided to us by the JCF. You will notice, Chairman, that when you add up persons in the group of children 13 to 17, 18 to 25, you will see, Chairman, that 51% of persons detained were between the ages of 13 to 25. We make that statement, Chairman, simply as a statement of fact based on the records provided to us. Page 5 details the ages and how many persons of a particular age were taken into custody. Chairman, if we look at cordon, curfew, and searches, which are provided, page 7, Chairman, and members. If we look at cordon, curfew, and searches, which are allowed under the Act, we will see that in this particular zone, 5 curfews were imposed, each lasting 7 and 12 hours. In each curfew, persons were arrested, processed, and released. The JCF records do not disclose any outcome. The legislation establishing zones does not define processing. We don't know what it means, but it's something that we have met in the fields in every area in which we operate, or what it entails, nor do the records of the JCF explain what it is. So, in Mount Salem, for the period that we're talking about, 4,604 houses were searched according to the JCF records. According to the police data, and this is what the JCF says, and I quote, much of the details of the searches were not captured. Neither is there any recorded outcome of any of the searches. Section 14 of the Act allows a member of the joint force to conduct searches of homes, places, vehicles, or persons within a zone without a warrant, but only, and I quote from the Act, upon reasonable suspicion that an offense is in the course of being committed or has been committed or is about to be committed, end of quote. The significant number of searches yielding nothing, according to the JCF records, suggests that searches, Mr. Chairman, were arbitrary and contrary to the provisions of the law. There is no record of any cordon having been established or conducted in Mount Salem. Page 8, Chairman, paragraph 25. We have been advised that in Mount Salem, that zone is in transition from the holding phase to the building phase, which started in April 2018. I'm moving on, Chairman, to Denham Town. And this, of course, is a community, an urban community. Paragraph 27 of the submissions, Chairman and Committee, Denham Town was declared a zone of special operation on the 17th day of October 2017. Paragraph 28 deals with the demarcation and the physical boundaries of the zones. So I've moved now to page 9. And we look at the joint force activities. So between the 17th of October 2017 and the 22nd of September 2018, 722 persons were detained. Of this number, Chair, 6 were persons of interest. However, 2 of the 6 were processed and released. An analysis of the data provided by the JCF disclosed that 79% of persons detained and arrested were under the age of 31 years old. The pie chart below provides a breakout of the different cohort. Persons between the age of 11 to 17, children accounted for 11% of the Chairman, moving to page 10, we break out the ages of the different ages and numbers of persons. So of the 722 persons arrested and detained, 616 were processed and released on the same day. Again, we have no definition of what a processing is or what it is to look like. And in relation to this group, there was no reason given by the JSC for the detention of the 600. That I have 22, Chairman, it should be 615, and I'd ask the committee to make that change. There's no provision in the Act that permits an arrest or a detention for the purpose of processing. This is a legislation that is very clear as to the circumstances under which anyone can be taken into custody and the circumstances under which any individual can be deprived of his liberty. And we say, Chairman and Committee, imprisoning, which is arresting and detaining anyone, even for a day, to be processed is contrary to law and contrary to the provisions of the Act. The records reveal that 6 persons were taken before a justice of the peace. That is of 6 of the 722. Of the remaining 101 persons arrested and detained, 38 were processed and released in relation to breaches of curfew. A number of others were interviewed, released, and some charged. Charged range from fraudulent use of license plate, indecent language, being in possession of ganja. 3 persons were charged for having an offensive weapon. Other charges included resisting arrest, obstructing the police, disobeying a constable's order. It is to be noted that the most frequently occurring age among those arrested and charged is 19 years, followed by those who reported to be 20, 21, and 22 years old. Finally, Chairman, we found that there was missing data. In relation to this group, we received additional data on or about January 22nd, 2021. And paragraph 38 will show the description contained in the letter to us from the Commissioner's Office. Paragraph 39 covers the period, same period we're talking about, October the 17th, 2017 to September 22nd, 2018. This new data, which we got for the very same period that we had been speaking about, records only arrest and charge of 144 and contains no data on the number of persons who were processed and released, or any person who was interviewed and released, as described in data given to us previously for the very same period. The recent data received on or around January 22nd, 2021 does not provide the ages of those arrested and charged or the periods of detention. So what we have is data from the JCF that we got earlier whilst we were actually engaged in discussions in the committee in 2018 that we had gotten at that time. And we asked for the data again, and this time it comes to us with different numbers. The criminal charges range from 38 cases of being in possession, this is now in relation to the 144 persons, of offensive weapon, possession of ganja, loitering, disorderly conduct, use of indecent language, breach of curfew, resisting arrest, threats, and the like. These offenses, Chairman, so far as we know, are offenses that are most likely to have occurred in the presence and sight of the law enforcement officers that would have required very little amount of investigations and are within the parish court jurisdiction. In conclusion, the latter data submitted by the police is incomplete and appears in several aspects to be at variance with the earlier data given to us. And that is of a concern, Chairman, because the first data stated very clearly it was 722 persons, that data we received in 2018. And then this data, which we got earlier, only contains persons charged rather than the full gamut of persons who were taken into custody, detained, and subsequently released. In relation to cordon and searches, Chairman, the data does not indicate the use of any cordon in this zone. There were 63 curfews imposed, and the recorded outcome, according to the JCF data, was, and I quote, temporary stability, end of quote. In relation to the number of searches of houses carried out, the JCF captured no details and had nothing to report. We have been advised, Chair, that the date for the transition phase from holding to building is not available. In relation to Greenwich Town, Chairman, what we find, going to page 14, demarcation, this zone was declared on the 1st day of July 2020. What we have seen from the data suggests that this zone is not particularly active. And we have made that from a cursory examination of the data, which came to us very late, and it seems incomplete. But what we have concluded preliminarily is that the zone is not particularly active. Of note, however, Chairman, is the fact that persons who are being taken into custody are not being taken before the justice of the peace, which is what the law says, that when you are detained, you are to be forthwith taken before the justice of the peace, because it is he or she who will determine whether or not you ought to remain in that status as a detained person, or what is to be done to you. It says whether or not there are reasonable grounds for the person's continued detention. Chairman, I have to make that point because we see it all across Jamaica, and it is something that we need to look at carefully as to this policy of taking in people, processing them, and releasing them. Law doesn't recognize that as a legitimate activity, not a legitimate activity of the Jamaica Constabulary Force at all. So, Chairman, the zone has not had any curfews or cordons imposed on it. 48 houses were searched. According to the JCF data, nothing was found. Moving, we are told, Chairman, that this zone is still in the holding stage. Moving right along to August Town, a zone was declared on the 8th day of July 2020. This is page 20, committee members, and of course we have the demarcation of the zone. Chairman, it is with regret that I report that we got the data very late and without the opportunity to analyze the data provided by the police. What we are seeing that a total of 102 persons were detained in this zone. A cursory reading of the data indicate that the reasons for the detentions were reasonable suspicion of criminal activities. We haven't seen any charges. Cordon, curfew, and searches, no cordon or curfews were conducted according to the records over the period. However, 20 houses were searched. No one was arrested as a result of any of these searches. According to the data we have received, the August Town zone started to transition from holding phase to the building phase on the 30th day of July 2020. We just have some comments to make, Chairman, on all zones. We want to move to paragraph 16 to emphasize that under the legislation, the powers exercisable by members of the security forces are particularized in the law and clearly prescribed. Remember, this is a law that carries criminal consequences or consequences for one's liberty, and therefore Parliament puts that out clearly as to how the law is to be operationalized. The limits on power are in general unambiguously expressed and spelled out in simple language. In all 4 zones, body cameras were worn only in the initial stages, but somehow its use seemed to have petered out. Currently, according to the data given to us by the JCF, body-worn cameras are not in use in any of the zones of special observation. We make some general observations. Paragraph 63, the unavailability of information on searches of houses or failure to capture details in respect of such searches in the Denham Town zone is an indication that the security forces have not learned the lessons of May 2010, when in the Commission of Inquiry, and I'm sure everybody here will recall, the inability of the police to provide information relative to the location where bodies were found or picked up during the operation. And this became a major issue at the Commission of Inquiry, so too was the failure by the police to record the particulars of the firearms assigned to officers deployed in the operation. And, Chairman, we expect that we are to learn from these events that have cost so much of social capital and human capital. There is no indication or suggestion that the weapons or ammunition assigned to members of the joint force in these zones were registered with the Institute of Forensic Science and Legal Medicine as required by Section 20 of the Zones of Special Operation Act. What is abundantly clear to the Office of the Public Defender is that in the majority of the zones, the joint forces seem to be operating without regard to Section 16 of the Act. That provision, Chairman, specifically mandates that every person arrested or detained should be immediately taken before a justice of the peace. It has come to our knowledge through media that Parliament, that the JCF has advanced to Parliament a proposal for the amendment of the Zones of Special Operation Act. We have not seen those proposals, Chair. We have picked that up in the newspapers, but we understand the proposal to include A, empowering of the security forces to detain and hold persons up to 5 days before bringing them before a parish judge. B, making the breach of a curfew order a criminal offense. C, criminalizing the prevention or attempt to prevent security forces from carrying out searches of persons and properties without warrant in a zone. D, empowering the security forces to seize tools of trade if it is likely to be used to commit any offense. E, removing the need for the Joint Command to advise the Prime Minister to suspend operation in a zone of special operations. F, empowering officers not below the rank of ACP in the case of the JCF, or a lieutenant colonel in the case of the JDF to establish a cordon within a zone. Without seeing the JCF's proposals, the reasons for such proposals or the objectives envisaged by the proposed amendment, the Office of the Public Defender takes the opportunity to remind all of us that any amendment to the legislation must comport with the objects of the Act as spelled out in Section 3. With respect to the JCF's proposal, OPD offers the following preliminary comments for consideration. A, to granting power to detain in excess of 5 days. Chairman, it opens the door for further abuses. We have seen not only in zones, but also across SOEs that the majority of persons are taken into custody and released. They are taken without, Chairman, reaching the legal standard of being reasonably suspected of having committed or about to commit an offense. C, We are not sure, Chairman, how it is the JCF can justify seeking this additional power to detain for up to 5 days, when in zones so far and states of emergency, almost 100% of persons detained are released the same day. That comment, Chairman, is more intended for zones, because the detention period under a state of emergency, according to the data that we have analyzed, is longer than a day. We don't see the justification why the JCF would want to be able to detain somebody for 5 days when their very data is showing us that they bring them in, process them, some of them are interviewed, and they are released on the very day that they are taken into custody. The security forces' power to detain, and under the state of emergency and matters related to the operation of security forces in that enhanced security measures, are now under active judicial consideration. And any amendment to the Zones of Special Operation Act, another enhanced security feature, should properly await the Court of Appeal decisions, as it may well have implications for the zones of special operation. I thought, Chairman, criminalizing breaches of curfew order. Chairman, we say that this is wholly unwarranted in matters of this nature. The police for years have been using sections 20 and 30 of the Constabulary Force Act. The creation of zones of special operations do not negate these provisions of the Constabulary Force Act, upon which the police have relied for many, many years in the prosecution of thousands of Jamaicans in the resident magistrates' court, now parish court. Chairman, C, criminalizing the attempt to prevent or preventing searches by security forces. We submit, Chairman, that this is an unnecessary call for additional power and an imposition on our resources. Section 30 of the Jamaica Constabulary Force Act already vests the police with such powers. In any event, the JCF itself has been invoking Section 30 of the Constabulary Force Act against persons who have videotaped their operations and have conducted arrests of persons who, these are citizens who start to tape and capture an operation, and in person and vehicle searches, if the provision can be invoked for such persons, it can be invoked for persons intruding in the prevention of or attempt to prevent such searches. The argument that Section 30 of the Constabulary Force Act cannot be utilized when the officer who is being prevented is a member of the JDF is rather dubious. The zones of special operation is predicated upon the joint security forces acting together. Cordons and searches are prominent features and prominent components of these operations. In cordon and curfew, searches are intensified. Section 12(2) of the Zone of Special Operation Act puts the members of the JDF on the same legal footing as the JCF. Even if this is doubted as a theory, in actual practice, the situation on the ground is such that the police officers and soldiers are invariably both present in cordons and curfew. So, Chairman, what we're saying is that we have, and it is known across Jamaica, we have had so many operations. We see soldiers and police acting together. Military commanders who are part of the planning of the operations always employ strategies to avoid any perceived mischief about which a submission for additional power is being made. Chairman, the seizure of tools of trade. Such a power should never be granted. Just should never be granted. A man's tools have always been exempt from seizure, even in hire purchase situations, Chairman. But Section 14.4a of the Zone of Special Operation Act sufficiently addresses that issue. A man's tool has to be immunized from seizure. We submit tools relative to his trade or his business in the absence of exceptional circumstances. And that is a time-honored principle established in law. And Chairman, we submit that that should never be changed, and that such a proposal ought to be rejected. In relation to the Joint Command advice to the Prime Minister, Chairman, we're not quite sure of the basis for this proposal for the amendment and the goal to be achieved by such an amendment. We're not also clear about the rank restriction for establishing cordons. And as we said earlier, we have not seen these proposals in writing. We have only picked up things from the media. In conclusion, Chairman, it is to be noted that the data provided has not revealed or shown the recovery of firearms, ammunition, nor is there any report of successful investigation and prosecution of any major crimes. I think that this is what we're after. I think it is the guns and so on. And the successful investigation and prosecution of matters. From the data supplied, it appears that the zones have only been effective in collecting information, primarily on young people. In light of the Data Protection Act, the public defender is concerned about A, the storage of data, B, the use of data, who has access to it, and the protection of the privacy of persons from whom data has been gathered. Finally, it is of no small concern as to whether or not the collection, storage, and access of these data and related matters comport to the Data Protection Act and ultimately with the Constitution. Those are our submissions, Mr. Chairman, members of the committee.
Thank you, Mr. Harrison. Any questions from Member Paulel, then Member Senator Golding?
Thank you very much, Chairman. I really appreciate the in-depth analysis that you have provided. And Chairman, I'm so happy to be on this committee because having been a member of Parliament for so many years, where I also am plagued with issues of crime and violence and what is it that we do about it. I remember earlier Ms. Golding's view, and which I share, that this problem is not going to be an overnight problem to be solved, and that there has to be dynamic approaches going forward. I myself, having sat here for the last number of weeks, I'm quite clear in my mind that the over-reliance on the coercive forces to solve our problem is not going to work, and rather we have to adopt different approaches, as we are seeing. You missed a presentation earlier on restorative justice and so on and so forth. I would like to just ask you a fundamental question, because we have been through this time and time again. We have been through the Gun Court Act, we have been through the Suppression of Crimes Act, etc., etc. What is the office's view on a different approach to how, and probably we shouldn't be calling these things crime plans. We should be calling these things how to make communities safer. And perhaps if you could just give us a view as to how you see a society emerging, especially our post-slavery, post-colonial society, where people view the police as Babylon. How do we move towards effecting greater harmony, a greater role for communities to emerge as safer places, and what would be the role of the uniform elements, the JSC, the soldiers in that milieu?
Chairman, member, you have asked a very difficult question, but I'll tell you what our views are, though I think you know that our jurisdiction relates to the protection of constitutional rights, and we have seen a great deal of violation over time. In fact, all states of emergency carries that very high risk. And we have seen that from the 1970s up to more recent times. I think what we need is a multidisciplinary approach to some of the problems that we have. There is no doubt in our mind that there are hardened elements in the society, and we have to acknowledge that there are organized criminal gangs, and the approach, therefore, to such a group would certainly be different from the approach to the younger ones in the community. So we would want to recommend that steps be taken to build, and I can only speak in general terms, but to build a society that has greater equity in it for everyone to participate and to see that they too can enjoy economic benefits for themselves and their families. So I would want to think, Mr. Chairman, that the committee, the Social Intervention Committee in zones, I didn't think that we needed a special law to have that, because that could have been done without it coming in legislation. But I do believe that each community and each parish needs its own plan for economic development. In these presentations, we did not see any such plan for any particular community. But that needs to be done, because we hold the view that we have to build from bottom up.
Thank you. Before Senator Golden, just a little clarification, Minister. the government of Jamaica. This time we have never announced a crime plan. We have known Plan Secure Jamaica is a holistic, whole of government approach to resolving criminal and other social issues in communities. That call has come from many other sources and has been criticized, but that is the policy of the government. Plan Secure Jamaica embodies the 6-point presentation, cuts across justice, security forces, social investment, and corruption, among other things. So that has been the policy of the government, clearly. I just want to clarify that.
Sorry.
Right?
Sorry, sure.
I really would like to respond to that because, Minister, I feel your pain. But I think what has emerged from me with the interactions with the various agencies of the state and otherwise is a recognition that we need to pursue things differently. But when I look at resources that are allocated for the various elements, I still believe that there is too great a focus on the coercive element rather than the kind of support that the people who are involved in restorative justice, the PMI, are getting. And I think that will have to be changed if we're going to see any meaningful changes going forward. That's my submission.
Not disputing, I just want to clarify the issue. We have Plan Secure Jamaica was not announced as a crime plan. Fighting crimes are part of the process, one of the 6 million.
Sorry, Minister.
Senator Golding first,
I know
Senator
Senator Golding, but I asked her just to yield to address it. As one who, in this Parliament, I recall making in probably 2017 a speech about the crime plan, calling for the crime plan. And I cited a number of times when the government promised, included meeting at the university, the crime plan. But we don't want to go into it, but for the record, since you're putting that we call, that you didn't propose a crime plan, the record is there that you proposed. The key thing we want to come together is to resolve it. I can show the data, the detail, but that's not where I want to go. It's only because you took us there, Chairman. What we want to do is to work together to really reduce this crime thing that is bothering us, that is gotten out of hand. So who's called for plan or who proposed plan is the solution that I really am interested in now, and not the semantics of it.
Senator Brown, if I had known I was yielding to you to make a point that you were then not going to go into, I might not have yielded. Mr. Chairman, if I might, Madam Public Defender, I thank you very much for your submissions today and for your presentation. I have a couple of questions in relation to the data that you were analyzing. I note the data that you referred to, the JCF data, was for, am I correct in saying that the data covered the period in the circumstance of Mount Salem and Denham Town, the first year of the zone that was declared in those two communities?
Remember, the period, the actual period is noted.
2017 to 2018.
To September 2018.
Right.
Yes.
And for the data that you looked at, and I note you said you got the data late, the period for the August Town and Greenwich Town communities, that data covered what period?
Because it came in late, remember, we kind of looked at it, and these zones were the later ones declared.
Right, so those zones were declared in 2020, so I'm trying to understand what period the data that you would have cursorily looked at covered.
Yeah, so that data that would have, for the August Town and Greenwich Town would have been from the date of the declaration to cutoff period to the date of the writing of the report. But that data came to us very late, and that is why the report contains that we did a cursory examination of it.
Madam Public Defender, I appreciate that it started when it started and it ended at some point. What I'm trying to ascertain is what are the specific dates? Is it a month after it started? Is it 3 months? What is the date that it covers in relation to the data that you would have gotten, albeit late, but you were attempting to draw some conclusions to assist us?
It would have started from in August Town, from the 8th day of July to January 21, right? In terms of Greenwich Town, this would have been earlier. Greenwich Town, a moment. That would have been from the 1st of July 2020 to January 2021.
Thank you. And so if I could just explore the data that you got, and I appreciate that you indicated that at a particular point the data covered certain heads that it then either those heads were absent in later data. If I could understand, do you have a relationship of ongoing data transfer with the constabulary force given the nature and the context of your office?
We do have that more established in relation to states of emergency.
Okay.
So we have a standard arrangement with the JCF. Now, not all divisions are compliant, but we have found St. James and Hanover to be exceptionally good with providing us data. And it's always on time, and if we need more, they are happy to give it to us. It's not an issue. As compared to, say, Clarendon, where that has been a very unhappy situation.
Is it that on this occasion, can you just indicate to us what your specific request for the data was? Because this wouldn't have been a part of that ongoing exchange. Were you requesting data on particular heads and didn't get it? Or can you just enlighten us on that?
Yes, so we would request data on very specific heads. I don't have the correspondence with me, member, but normally, from the first time we presented on SOE in 2018, we had established specific heads. Name, to give an example, name, date of birth, place of residence, date of detention, reason for detention, date of release, those sort of standard questions.
And who is arrested and who is charged and so on.
And then we would want to know, of these persons arrested and detained, how many were charged? What is the nature of the charge arising out of the arrest and detentions? So those are standard questions that we have developed from early.
I thank you for that, because part of my, I don't want to put it any higher than concern, is that in looking at the data that you're citing, that you obtained from the JCF here, consistently across the 4 zones, you've had any arrests or charges arising from arrests?
No, that's not what I've presented.
Please correct me, please.
So let me start from the back. Madam Member. What we have said very clearly is that we haven't seen, for instance, any gun charge. I'll start at the very final part of our submissions. Any finding of ammunition and so on. So walk with me, member. In the first set of data released, in that context, Madam Chair, Madam Member, I question the reasonableness of the detention. If you look at the other period, Madam.
If I could interrupt you, Madam Public Defender, because
Sure.
It is your concern about the reasonableness why I have engaged you in the data and how it came and what came. Because this, Mr. Chairman, this committee will recognize that different numbers have been reported to this committee. Pardon? One zone, yes, but even in relation to this one zone, the data that we have prior to today submitted, and it was part of the in-camera hearings we had, Mr. Chairman, are not in congruence with what the public defender is reporting that she received. And so my question is, are we talking about accurate data in this report because the public defender is having to draw conclusions on the basis of what she received, which is inconsistent with what we have gotten? And that is my concern.
I don't have my copy of documents. Yeah, it's something that has been looked at. We have reports on a quarterly basis, well, 60 days, and they are accumulated from time to time. So we'll have to cross-check it if there's any serious variation.
I think we would need to do that, Mr. Chairman, because we've taken the approach in this committee that we want to look at empirical evidence in our analysis of how this has worked and what our recommendations are going forward. And so I think we need to be clear on what is the basis on which we are going to arrive at those conclusions. Madam Public Defender, I thank you for your indulgence.
If I may, Chair, I quite agree, member, with the need for accurate data. And because one of the things that we always emphasize when we make these submissions is that the conclusions are drawn only from the data. And in a previous set of submissions, in 2018, much of the data is missing. Say, for instance, Madam Member, I believe that the Parliament would want to know the outcome of searches of houses, because this is an important event. Our homes are normally our private space, and we know that a search can be done of that house, provided the standards are met. But when you look at the data, and we have asked for that data, you see nothing captured. So there is no doubt that we need, that is the JCF, needs to pay greater attention to the collection of data, because it is also a means by which we can make proper analysis and also to protect rights.
Chairman, there's some questions here. It strikes me that the collection of data is that they're good at personal data of the poor people in the community, the 581 or whatever number. They collect data on that, but the other data is not available. But there are some other concerns about data. The Office of the Public Defender has reported that they receive information in Mount Salem of 4,604 houses searched, and that I believe is on your report, right? However, when JSC came to us, JSC reported for Mount Salem 3,500 residents within 500 households. So I'd love to hear from the security forces how they square that. Is it that some of these 500 households were searched up to 8 times, because 8 5s 40, to give you 4,000? So that's not clear to us, but if they're searched multiple times and we're not getting the outcome in guns and arrests, it strikes me that we're like youth and thou, running from the boundary, only to be told thou shalt not bowl, because it's going back, the ball is going back from whence thou came. So I'm concerned about the data being submitted to us. Also, I don't know, PIOJ, for example, could be dealing with data today that is 2018. You certainly won't be able to help the economy. So I have that difficulty with the data that is being provided to the ODP. They definitely need reconciliation, and the police need to come, security force needs to come and share with us the updated and give us along the line that ODP requested, OPD. Let me ask a question directly of the ODP. The 582 in Mount Salem, detained, that would be in the clear phase in the early part. So in clearing, they only charge one person. So I don't know if they would achieve.
On their data,
yes,
on the JCF data, one person was charged.
So what would that say about the clearance of this community?
I want to think that those are, you know, we question the reasonableness, and we question the strict adherence to law by the JCF, because there is a legal standard to be met. And if we do not have that, we will also have a breakdown in the rule of law. A legal standard in any democracy, there is a legal standard that has to be met before anyone's liberty can be interfered with.
Would I be fair to say, Madam Public Defender, that the OPD is saying that the law for body-worn cameras is not being adhered to by the security forces in the zones of special operation?
What we're saying, member, is only that which is contained in the report. And what is contained in the report is actually a report to us from the JCF. We do not know why they are worn only in the initial
Put another way,
phases.
The security forces reporting to you that what the law requires is not being done.
If that is a way, that is effectively what the report is to us.
And we know the Police Federation came here and asked for it to be done. So there's clearly a reason, a failure here. But you also mentioned the forensic accounting of the ammunitions and firearms assigned to security officers. The law required that, am I correct? Yes. So,
that we did not see that, and we mentioned that in the context, member, of us as a people having to learn from our experience and also from the recommendations coming from the Commission of Inquiry. You know, it is a continuation that we need to always put recommendations in place that can assist the security forces, can assist the citizens of Jamaica in daily life.
When I voted for the bill, I voted this as part of the quid pro quo for greater restrictions on the citizens, that this would be done. You have reports that it's been done, that the weapons assigned are being reported.
Member, if you look at section 20 of the law reform zones of special operation, it says we have no report on that, where weapons and ammunition that are assigned to members of the joint force shall be registered.
I know, and that's why I'm asking if you have any report that is being done.
We have no evidence of it being done.
So somebody could easily conclude that body-worn camera, which the law requires, is not being done. Forensic reporting of the ammunition and firearm not being done. That the security forces
Mr.
are
Chairman,
not complying.
I apologize. On a point of order, Senator Brown.
Sir, Chair.
On a point of order, it can't be that we are concluding that evidence that it is not being done is equal to evidence that it is being done.
Well, I'm satisfied with
the basis on
their report.
But the basis on which, with respect, Madam Public Defender is making this conclusion, I'm not clear on, because I am not aware that she's saying that there is a report that says no body cameras are being worn, for argument's sake. So the comment in the report at paragraph 62, in all 4 zones, body-worn cameras were worn in the initial stages, but somehow its use seems to have petered out. What data, Madam Public Defender, gave you information to draw that conclusion? With respect, that would then allow Senator Brown to make the conclusion that he's making. Without that clarity, Senator Brown, you're going outside of the rules of logic.
If I may, Chairman, this paragraph 62, Madam Member, is that information given to us. Information given to us.
By who, Madam Public Defender?
By the Jamaica Constabulary Force. We have it in a written document from them.
Chairman,
if I could, Chairman, if I could just make a statement. The purpose of my report is to report the facts as we have received them. And the aim of that report, members, is to try and see how we can improve a situation. That is my sole purpose here.
And I do appreciate that, Madam Public Defender. Thank you for that statement, because I agree that that is what we expect from all who present here.
Chairman, I'm not finishing now. I have received the report like everybody else. The report says, based on the report to them.
But you just
let me finish now.
You just say you had different data.
Let me finish. Let me finish. The report that they have given us has led me to conclude, and natural just tell all the police to come and say, no, they quoted wrong data. But the data that they have given to this committee is that the forensic reporting is not being done. Secondly, body-worn cameras wasn't just for the initial stage. It was all the time the act is in place. That is not being done now. The Police Federation came here and said, we want to wear it, it's not being done. That's sufficient for me to say and to ask, am I to understand that the rule of law, the law that we pass, is being observed in the breach by security forces in some aspects of the law?
Senator,
and I'm asking that of them.
Senator, the question you have widened your comments a bit. The report did say that body-worn cameras are not being worn as should that in section 62, but it does not say that the forensic identification of the weapons are not there. So she did not get such a report, because all of the police equipment, all army rifles have a forensic footprint within the army.
And there's a requirement that those in the zone be registered with them. It's not being done, is what I'm asking.
No,
is it being done?
There's nothing to say it's not being done. She did not get a report.
And my question, is it being done? Because why is it in the law if we're not abiding by it? Then we become a society where the rule of law doesn't apply to us.
We can get that data as required and we'll clarify it, but it's not in the report at this point, so we can't go and debate it.
I appreciate all that. Another issue I want not finish yet. Not finish yet.
Senator Sinclair.
No, just because the chairman was speaking. Chairman, there's some comments from the old PD in respect to proposals for amendment to the bill. I hope that this committee will be prepared to share with the Office of Public Defender, given their mandate to protect the Constitution. And having regard for what the Attorney General had said when the police presented, have regard for section 13(4) of the Constitution, that the matrix that we develop be shared with the OPD, and we receive comments from them in respect to those proposals, so that when the committee meets to look at the matrix, we can have regard for what the constitutional defenders are saying to us. Well, so I hope we can agree.
I don't know if I can, what you
don't know if we can agree.
The comments are available, the comments given by the police are available to the public defender. If she asks for them, they'll be made available. And her comments will be made up to you as a committee member to make a decision on. Parliament's position is to make decisions. I'm saying to you, the recommendation of the Police Federation and the police is available to her as a public officer. She has not yet had them yet, but they are available. And her comments on them will be made to us. The decision is yours. You are the legislator. And we'll make them in here.
Yeah, but I also want to be informed.
Yeah, but you get informed from her comments.
No, what I read and heard from them is that we have noticed from the media.
Yeah, but that was not a fault of any of us.
I'm not trying to find fault. I'm trying to find solution.
No, I'm saying the process, Mr. Brown, and I will not vary it. If the public defender wishes to further comment on the recommendation of the JSC, they are available to her without any hesitation or objection.
And therefore, my suggestion to the committee is that we share it and not ask them to
hold on. No, it's not going that route. I don't need it further. Her commendation will be brought back to this committee, and as a member of the committee, you will have the responsibility to comment on it, and your colleagues decide at what be included in the legislation.
Let me see if I hear you right. You're saying that they will be allowed to comment on it.
No, it's not allowed. It's their right to do so, and I can't stop them.
And that right will be offered to them. The exercise of that right.
I don't offer right. It's their responsibility to ask for it, and it's free. It's there.
All right, well, let me ask them. Is it, Madam Public Defender, your desire to receive the proposal from other agencies for change in the ZOSO Act so that you may be able to comment on it and the committee may benefit from your comments?
Chairman,
hear all views, and our job is to legislate. The public defender has a responsibility, and I respect that, and she will get, if she wants further information on the proposal, it's hers. It's in the public space, it's in the media, but she wants the actual document, she can have it.
Sorry, Chairman, we took one set of proposal in camera.
No,
that's from the JDF.
No, JCF was not in camera.
The JDF was in camera.
But it's
So
now
that's
in the
not in the
document.
public space. And they made proposals. So the question I asked of the public defender,
don't.
is it your
What is
desire
here?
to have these proposals?
The recommended here is on the JCF proposal.
But
If
not
you
the
want-
JDF one?
It's here.
No, I'm in this committee as a member like everybody else, you know, and I am asking, are we minded to provide both the JDF and the JCF proposals to the public defender? I'm not backing down on that.
But there's no problem with it.
I'm here in the committee saying they have no problem with it. So
No, what you're saying, no, not when we call it in a binary. If the public defender requires an arbitration, she has it. It's a public document. I'm not going to instruct the clerk to send it to anybody. It's available to everyone who wishes to see them as proposals. And if the public defender feels strongly about it, fine. And we respect the public defender, and she have a response to send back her report here. You as a legislator will consider and decide. Okay?
Mr. Chairman, Madam Public Defender, looking at page 3 of your report, and you refer to the 582 persons, and then you say that only one single person was charged. But then in paragraph 17, you said that it leads you to the question whether there were any reasonable grounds for the arrests and detentions in the first place. You said you got the information as to the reasons for those detentions, arrests and detentions. Are you minded to share what was contained as those reasons for the arrests and detentions? Now, also, a charge requires something else. It may require a statement from a complainant. So the police could arrest and detain someone in the first instance on information. You agree? Oh, good.
We're aware of that, member.
Very well. But they would not have gotten a statement which could lead them to a charge. Would they not have
We
to
understand that too.
Right. So I would want to understand why it is that you then say that there were no reasonable, in effect, you're saying that there are no reasonable grounds for the arrests and detentions in the first place. One. And let me just go on and you can conclude everything. That I want to also find out from you whether this issue as to processing that you are speaking about, and I got the impression from your report, I may be wrong, that you do not understand the processing and what it entails. Processing, as I understand it, and I've seen it from, in fact, in St. James, where I'm from, it was something which started under a previous Minister of National Security, where persons were taken up in a fishing expedition. And persons were taken down and then they were processed and released, yes. So I'm getting the report from, the impression from your report that you do not either appreciate that it is something that was done and seek to give the impression that it is only under the ZOSO that activity would have taken place. What I also want to find out from you is whether you have gotten any complaint from anyone, whether those 582 or anyone within the ZOSO. Not the police, no. I'm referring to citizens. Any complaint, written complaint to you of any abuse of their constitutional rights that you would have to investigate or have investigated since the commencement of the ZOSO? Have you commenced, since you have gotten these reports and done your analysis, has your office commenced any investigation in relation to any abuse of the constitutional right of any citizen within the ZOSO? And if so, what has been the result of your investigation? And lastly, I remind you, yes, if you don't recall. Lastly, have you, in relation to what I see as a lot of operational, what you are saying is a lot of operational deficiencies, because the legislation provides for certain things to be done. Have you written to the Commissioner of Police or the head, the Chief of Staff of the Jamaica Defense Force in respect to what you have put out in this report of the various deficiencies about the arbitrary arrest that you make reference to and the various other things that you have a concern? Have you written, and when was that? If you have written, when was that done?
Perhaps, colleague and member, you could amplify your last question, whether or not I have written to the JCF or the JDF about the arbitrariness. Well, you might not recall.
Sorry, any of the concerns that you have highlighted here and the arbitrary arrest
under to the attention of Parliament.
Under the ZOSO.
We have brought the arbitrary arrest and detention to the attention of Parliament in reports dating back to 2018. And every opportunity that we get to present here, we make ourselves available. To answer, going from the bottom further, starting from the bottom up, and you can catch me up. I'm looking for a specific paragraph where we speak about complaints, and it's related to, pardon? No. Where 60 and 61? All right, 60, I don't think so. I think it was at the first part of the report. No, I'm aware of that provision.
In 60, in which Senator Brown has made reference to.
No.
And if I read it, it says, from the very start of the first zone, Mount Salem, St. James, there were no appreciable complaints to the Office of Public Defender. And then you then conclude that one suspects that the absence of complaints may be attributable to the level of authority wielded by the security forces. You know,
member, that is a paragraph I was actually looking for. So I thank the other member for pointing it out.
Yes.
The fact, if I could now answer your question.
Madam, what I'm trying to appreciate, you know, is that you state one thing and then you move it to a particular conclusion. Yes. And I find it a bit, there's a chasm that exists. And the fact that I live in St. James and I associate with persons, in fact, I represent persons who live in the ZOSO. And, you know, some of these comments that I see you making here, I don't. It is strange to me because I don't get that from persons who reside in the ZOSO. In fact, I find that there is, in the general sense, a good relationship between the law enforcement officers within the ZOSO as against citizens who do not reside in the ZOSO. And they go so far as to facilitate even entertainment events without persons have to go and get the usual required permits under the noise abatement. They allow them to do many things for the social interaction of persons who reside within the ZOSO compared to persons who reside outside of the ZOSO in Mount Salem.
Does that include Andrea Horton's skate round?
That's why I asked you the question, whether you and your report says you have never received or you have not received any appreciable complaints. But then you are making a comment about the arbitrariness of the... Let us say that you have not received any complaint. Has your office, based on what you have said here, gone into the ZOSO community and did an investigation, find the persons who you say you got notice of, 582 who were arrested? Have your office gone and done investigations, which you have a right to do under your legislation?
Can I now answer, Mr. Chairman? First of all, the fact that a citizen does not complain does not for 1 minute mean that his right has not been violated. And I need to establish that clearly. The fact, and we state it in our report clearly, that we have the areas of complaint have related to states of emergency in the main. And it is stated very clearly here that we have not received any appreciable complaint. We may get some telephone calls. It does not mean that the 582 who were taken up and processed and let go, it doesn't mean that those rights were not violated, member. That is a simple fact. And Jamaicans have a way, it appears sometimes, to accept virtually one's fate in the situation. And we have never said that there is any tension between the police and citizens. We are not talking about that. And in making a report to Parliament, member, I'm entitled to draw conclusions from the office in which I sit. If you don't agree with it, that is entirely a matter for you. You can discard the entire report. You can take aspects of it and say, I might be able to rely on this. The 582 people did not come to the Office of the Public Defender to complain that they were taken in. Because you know something? It is with regret that many people virtually resign themselves to being picked up. And that is my understanding of being in Mount Salem and in the parish of St. James. I think you had asked me another question. Could you remind me of the other question?
Since you have that viewpoint, that's what I'm asking. Since you have that viewpoint and your office on its own motion can go and do an investigation, and you have that view, tell me if your office has gone into Mount Salem and found any of those 582 and would have conducted any inquiries into what you have described as an arbitrary arrest.
Is the member saying it's okay to scrape up 582 people?
It is not.
Is that what you're saying?
No, Senator Brown, it is not 582 at one time because you are talking over a period which runs from September 2017 to the 15th of August 2018.
Even if you scrape them up one, so, is it right? Because I don't believe it is right. I don't believe it is right.
But
it is disingenuous. And it is unfortunate that the comment is made in the way that it is made. That is my opinion.
No, we're not here to unduly criticize. I think what may be of concern, Madam Defender, is that it's our response to look at your report, and improve on what we are doing. I think what may, and it's not necessarily your responsibility to do so, but what may be missing is that the zones of special operation are introduced in community with particular circumstances outlined. And therefore, all that has to be taken into account in going forward. You know, I mean, if I may say, on the extreme side of an arbitrary arrest, Miss Tika, and a real lady, that's her name, is calling me to get her 18-year-old son who graduated from Mandan and come to live with her to look at a job in Montego Bay, is to get a post-mortem done. That's what she called me about. Because him just come to the community, a man walk and shoot him, right? That's the other side of the coin which you're trying to prevent happening. Or Miss Joy, who was gone to help because that mother gone to help somebody to prepare lunch for those who cannot afford it, for the street people, and a man walk up to the shop and shoot him in the presence of the soldiers. So the two things have to go in why things are being done, and certainly I have to come to a balance. So I'm not saying your report is necessarily to be ignored or it should not be, and that's not what I don't think that's what the attorney is saying who has knowledge of the area. But if taken in isolation, it could convey the wrong reasons for what is being done. We understand your concerns and respect them, and they are genuine there, but it has to be done in the context of all the other reports we have, which is why we have had the JSC and the JDF and other reports here to consider, and I urge the members, we have to look at all of them, including further comments you may have to make. The state of emergency today is quite a different thing from what emerged out of independence, and I don't think any of the people who wrote this law, our constitution, they were all well-intentioned, accomplished individuals who had the nation-state interest at heart. So in fact, you know, they want to go to the name, but they're distinguished Jamaicans. And the way the state of emergency was written then is quite different from what it is today because of how it was applied. There are at least 4 or 5 different states of emergency before we got to the era we are in now, when there's quite a different application. It may be possible to be improved when the courts finish looking at what might have been weaknesses in there, but states of emergency are still a necessary part of an executive tool in dealing with particular situations.
Mr. Chairman.
Sure.
I thank you for your comments, and I want to support your comments, but also to make the point, the very obvious point, that in the deliberations of this committee, we are reviewing the operational aspect of a piece of legislation that is fundamentally intruding on the constitutional rights of Jamaican citizens. And in doing that, it cannot be that our deliberations are going to be informed by conclusions that are not based on data. And that is my concern, because quite frankly, in looking at the data presented and the conclusions drawn in this report, and looking at the previous reports submitted to this committee, there is a clear break in the consistency of the data that is apparently coming from the same source. Now, I make no conclusion, because I do not have any evidence to support it, that the error is the error of the JCF versus the error of the public defender, or the other way around. I don't have any basis to say one or the other. What I am suggesting is that rather than going to an exploration of conclusions that we can't quite understand where they're coming from in relation to the data that the public defender said she was given, we now have to go back and reconcile that and then determine whether or not there is a basis to ask the public defender to relook at the issue, or to ask the JCF to explain to us what the anomaly is about. But we're arguing about conclusions that we really can't rely on right now.
The issue of search, I said, we have the issue of search and searching of home. That's reconciled. I suspect in that case more typo than a real deal, because there's not 4,600 housing. The JSC have all maintained that. Mount Salem is a small community. And as opposed, to other
Mr. Chairman,
areas.
remember we have information about arrests and charges, you know.
Those
and that has been presented to the committee.
No, those, as I said, they have to reconcile. They're on record here. We find the JSC, JDF, but it's not, records cannot be debated. Data cannot be debated. We must get all the data together and get those there and reconcile them. And I'm saying it's not a reason to debate that with the public defender.
It's clear, Chairman, that we're at one, that the records need to be reconciled. One said given to the Office of the Public Defender, on camera. When I recall what you said, sort of, Minister, that it takes time to
No, I have to make a sort of watch it. The cameras that the police we inherited in the police force were not workable. And the police set about to buy new cameras. So through the application in the particles, they might have just realized they weren't working. Some of them went bad. They were not suitable for the tropics. They were gifts to Jamaica. This government has taken the decision to acquire certain vital equipment for the police with taxpayers' money. So they are ours. We run them. We operate them. And cameras have been ordered to be brought in place. You can't buy them off the shelf. But those that they had were inappropriate.
Let the record
there are legacy issues.
That's the reason why they're not being warned.
I would say we'll ask the police commissioner to indicate why, formally. I'm not telling you no because I'm aware of that.
I know you're aware of it, but we pass a law saying this must be done, and it is not being done. There needs to be an explanation to the parliament as to why it is not being done. And I don't need to wait until I ask a question on a Friday that may never be answered, Charlie.
Finish that. If there are no questions, may I thank the public defender and our team for their detailed and spirited presentation at the time. Thank you very much, Madam. Now, let me apologize to the PIOJ. I don't set the order of, the number of presentations be taken. I think based on the presentation, the Parliament looks at it and figure we could do all three. But of course, as you're present, it took a little bit longer in going through a number of them. I still want to say that in general, I'd love to see a bit more, and I'm hoping your presentation will have that. More comment on the legislative side of the program. I think we're getting, and of course, in the case of the public defender who must review the operations and then make comments. And she, in fact, I comment is one of the few presentations that have made direct reference to the legislation and her comments on what might be included or not be included. And I want to give the Defender's Office credit for that. A lot of the other presentations are coming to make a case for their own operational support, literally, rather than right? Rather than looking at the legislation, how it relates to policy, and why we need a legislation to execute certain policy program. Because I agree, a lot of the things we're doing in ZOSO could have been done by program policy, but the history of the government of Jamaica, and I don't mean any particular government, is that we establish programs and then change them when pressures reach at a particular point in time, and they get sidetracked, and policy drift leads to failure at all times. And a lot of the program are overwhelmed by what I call reactive decisions rather than prescribing a solution and following it through to the end. But throughout this discussion, the zones of special operation, an important piece of legislation in the overall. In fact, it's an approach to try and bring some discipline to our intervention in these particular communities. The 100 communities identified by the PIOJ, which would, some 20 to 30 of them would qualify for the zones of special operation. And I said that I'm a little bit, disappointed that much wasn't done in terms of what are the conditions leading to the establishment. But those conditions, I think the first work was done in 2008, Dr. Henry. That's the first time your child would recall, the first analysis of the socio-demographic of the communities. Go ahead.
I'm sorry, Minister, I'm not hearing a question.
That's saying the first review to identify these challenge communities were done about 2008 or 2007?
2010.
2010, okay.
It followed the events of 2010 when they arrested the Christopher Coke.
2010. So that's 10 years ago. And we have been we have not had a consistent program intervening in them. In fact, I recall when the CRP program was first designed, there was supposed to be a $100 million US loan to start the program going. The loan was neither active, I don't think it was assessed or even, well, it was never concluded. Am I right?
Right. It was designed not to be an intervention program in itself where interventions were carried out by the PRJ, but rather be a framework for coordinating and enhancing delivery through the operations of other entities that are on the ground.
We're going to have to come back and explain everything, because that's the root of all of this review. That was the beginning of the whole process, which has remained in abeyance. So the legislation has now been brought in to provide a level of a legal framework in which to intervene and maintain the discipline of the government institutions to stay the course in these areas. It's almost the same 100 communities. Some have deteriorated more, some have been a bit improved, but there has not been the kind of comprehensive, holistic program. This is the first time it is being done in the clear hole and build policy. Limited to 2 fewer communities, but that's where the budget allows us. But the object is to really aggressively approach them. So let me thank the public defender for presenting our team, and Dr. Henry, we're going to ask to return. What's our next sitting is? The 3rd of March. So there's a little break. I'm sorry we took your evening, but it might have been useful in your own role to hear the comments of all the other agencies here this evening. Dr. Henry. So can someone move for adjournment?
Adjournment, Chair.
Yeah.
I did ask at the meeting that JSC came for a copy of the Barrett Town report that they said informed them, and Barrett Town social. So again, I'm asking to the Barrett Town report that JSC said they use. I'm asking to the clerk if you could ask JSC to share with us.
Right. Okay. Yeah. I'll ask me to follow up. Okay. At the same time, Senator?
One other thing, Chair.
Okay.
Given, I don't know what will happen after the 24th, but given that Charlie will not be able to get back to Mobile before the curfew will leave. I know you're exempt, but I'm just wondering if we may want to bring the time earlier.
1 o'clock?
At 1 o'clock start, so that it allows to leave in time for Charlie if he gets his pass. I know you are good, but there are other people who may come who are not.
We did a representative from Montego Bay. We tried to get them out early, but yes, the curfew now begins at 8 o'clock, so we want to take beside traffic congestion and time.
Yeah.
But Senator,
some you may want
Senator is a what do you call, officer of the court, or remember?
No. That's the reality is that if we put the curfew time earlier, then we need to.
So we will go for 1 on the 3rd of March.
I'm comfortable with the earlier start.
Okay. So we can get out earlier and be, assuming we still have what is today's date? It's 14 days? Yeah, we'll still have the curfew at 8. All right? Now we have the formal letter. Thank you. Let me wish you all a good weekend and a little break here, but we'll be busy otherwise. And in fact, the PRJ will be busy too during the budget period. But thank you all, and I see you on the 3rd of March. 3rd.